Unfortunately, how he lost his cool, how he blew it, how he, said stuff he shouldn't have said.
I'm leaving this message with you to tell you, you have insulted me for the last time. You don't have the brains or the decency as a human being. I don't give a damn that you're 12 years old or 11 years old or that you're a child. You have humiliated me for the last time with this phone.
But we're not getting the legal stuff in the background as to how it got this big.
Well, Don, that explains some of the anger, certainly. But if someone is shooting for custody, and that's what Baldwin was doing in this case, and you've got a visitation issue, perhaps this is how an attorney, demonstrates to your client, this is how not to act. This is where you keep your client from being stupid.
Well, I think that's true, and I think, as Dave pointed out, if you're representing Alec Baldwin, it's all about context. It wasn't a good thing to say. I don't think anybody thinks it was a good thing to say. Parents get frustrated with kids. Parents say things they shouldn't say. But if you have that background and put that into context for a judge, because I don't know what happened here, but I see that in cases. I think all the attorneys here see it in cases where someone is alienating the other parent, and it's frustrating because you go to court, you get a contempt order, nothing happens, you're back, you're spending money. Sometimes you just blow, and I don't think what he said was right, but in the context of how he said it, if what Dave's understanding is correct, I think that has to be pointed out to the court.
Bonnie, I think he lost visitation for at least a period of time, so it's got to undercut his custody case, obviously, but it's even worse when you lose visitation for a while.
One of the things that I find interesting from an intellectual point of view as parents who become angry in these custody battles is that they forget about technology. They forget that everything in the world can be taped. They forget what happens at the emails, and emails are never lost. And so that when they misbehave, whether it's right, wrong, or indifferent, it's probably somewhere able to be brought back. And so, and the other upsetting point, in which I try to tell clients, is that you're the adult. You're not the child. You have to act above the fray, because you're supposed to be the one who's in charge and control, not the kid. But when you hear about these emails or these voicemails being leaked, it's just stunning to me that people forget that these things are recorded and they're always there.
So, Ellen, you always tell your client, don't put it in a voicemail, no recorded devices, and no email.
Bonnie's point is extraordinarily well taken. People do forget. They become impassioned or enraged or frustrated, and they forget. But on the other hand, children do not have perfect parents. And although no one would want a child to hear what this child heard from her dad, at the same time, children who become almost complicit, willingly or unwittingly, with the other parent, perhaps sometimes need to hear, this is my time and you're not there, and that's wrong. We almost sanitize our clients to the point that they have no more feeling that they show their child. I understand where you're coming from, Muffin. It's just that it hurt Daddy a little bit. Do you want to have your father saying that to you? This child could clearly hear this man's pain. This child could clearly hear this man's frustration. And if she lived with him, there would be no screen from the media or a judge saying, cut that out. It was an understandable reaction. Child shouldn't have had to hear it that strongly, but maybe the child should have heard something.
Dave, they say that the voicemail was not sealed under a court order, but again, the million-dollar question, and you probably ferreted this out in other media, is who sent that tape to the media?
Well, to me, the dilemma becomes, I don't think that this 11-year-old child has a press secretary that she has access to. I think it's pretty clear where it came from. And quite candidly, if I was Kim's lawyer, I'd be furious at her. Because to me, this is the tape that you don't put in the media for public consumption, but you bring to court that day. And you play it, and for the first time the judge hears it, that judge is going to be blown away. And I think it makes her case so much stronger in the courtroom rather than the court of public opinion. But, I have a feeling that she doesn't really think that thoroughly it's not so much of winning the court case as much as humiliating Alec.
Absolutely. And in the end, it doesn't help anybody, does it?
It doesn't help anyone, but I think that no matter who the personalities are, we see this all the time in custody cases. We see anger, and we see inappropriate reactions and inappropriate statements to
It's
children.
rare that you see it published.
Exactly.
No, it's an interesting thing. This was on a voicemail, and there's not an expectation of privacy in a voicemail. But in Pennsylvania, which is more stringent than most states, if that conversation had been with Kim Basinger or the daughter, and Alec Baldwin didn't know he was being taped, that's a violation of the Wiretap Act. And we run into that all the time in Pennsylvania, where a client walks in and says, "I have him on tape," or "have her on tape." You can't use it; it's not evidence, and we as lawyers can't even be involved in it because they violated the act.
Well, that's a great point by Don, because our clients, they are dying to get the dirt on the other party. And they have that tape recorder by the phone. Sometimes they even goad the other side. They push that button because they know what the buttons are after all these years. And all they want to do is get that person on tape, and then they bring us the tape, and we go, "Sorry, can't use it."
But if you look at the bright side of what happened with Alec Baldwin, it started a national dialogue. I think about when celebrities become affiliated with the disease. Look what Michael J. Fox has done for the awareness of Parkinson's disease. There is a problem, and the courts aren't equipped to address it because they're courts. They're not mental health clinics. They're not living in the living room. That children are alienated from parents systematically, deliberately, maybe not maliciously, but effectively. And those children lose a parent, usually a father. If Alec Baldwin's message brings this to the national debate, then I'm sorry for his daughter and I'm sorry for what he's had to go through. But perhaps we'll start to recognize some realities of divorce that go well beyond your neighbor's issue and really affect the fabric of a generation of children.
And again, the other lesson we may learn from this, Ellen, is that if you do speak in such terms, even if you have justifiable anger, if it does get out there, not only are you going to lose visitation, but you could lose the war, not just the battle. He may end up losing custody because of this issue.
It would be a shame if he did, and it would be naive and shallow as an interpretation if he did. I agree with Dave. If I were the attorney of the wife, I would have been far more upset than the attorney of the husband. This didn't belong in the press. What he did was not premeditated. It was out of frustration and anger, apparently. What the person who sent it to the press did was motivated quite differently, and I think ultimately is far more destructive for the child.
Which could upset the judge more.
Certainly so.
Yeah.
And that's what we're going to wait and see what happens. All right, Paul McCartney and Heather Mills are going through a very acrimonious divorce in the press as well. Again, Bonnie, is this divorce by press? And who does it hurt? Does it help anyone? Does it hurt someone?
Well, it's probably not going to affect Paul McCartney at all. I think that he's got the world opinion on his side, and I think also the fact that this is a 4-year marriage. He didn't do a prenup because he was so in love, and he wasn't even thinking about that. I don't think that no matter what he does, he's going to be affected by it.
Hey, Bonnie,
Yes.
I understand that prenups may not be enforceable in Great Britain, which was the reason that I heard it was never done.
Well, Ellen and I had a case together several years ago, and we found that British law does enforce prenups.
Okay, good.
So they were enforceable over there. And in fact, they're much more ironclad over there than they are here in New Jersey, and I would assume Pennsylvania.
Well, Pennsylvania's probably enforces prenups more than most other states. Would you agree, Dave?
Absolutely. And the public policy in Pennsylvania is really for enforcement of prenups. And a recent divorce code amendment, again, reiterated that and gave it even more teeth than it ever had before.
They're basically looked at as commercial contracts here.
Yeah.
Well, they do in New Jersey under the act, and it was a 1989 act where the prenups will be enforced with a lot of teeth as long as there's full and complete disclosure. Right. And it really was part of the DeLorean case in our state that really brought that to a head. But if all the disclosures there about assets and debts and earnings, whatever, everything is going to be enforced, even if it's potentially a bad deal by your perspective or Don's perspective or Dave's perspective.
What about if it's given to the dependent prospective spouse the night of the wedding or that sort of thing? Will duress
Well, that's
work in New Jersey?
yes, duress will work, but I have to say in Delorean, if I recall correctly, it was given to her 5 to 7 days before the wedding. I tried a case where it was given 8 days before the wedding, and they were all enforced. Because they had the attachment, they had the assets.
Ellen, interestingly enough, when all is said and done with the Strahan case, maybe the bottom line is that Michael Strahan might have done better if he didn't have a prenuptial agreement.
We won't know.
And no guesses need to be taken, and perhaps best not. But Dave, in some ways, and I know you have taken a look at the prenuptial agreement, isn't it fair to say that perhaps some mistakes were made? Maybe this is not the way to create a prenuptial agreement.
Well, I think what Ellen said earlier was the whole presentation of the prenup. When it's, instead of being wife or husband and wife, it was player and spouse. You know, you got to look at where it's starting from. They didn't think there was any equality to begin with. And that's one of the issues with prenups is, you know, someone has to give something up, but you have to get something in return. You know, I feel awkward as to whether it would be better or it would have been worse. You know, he had a pretty good legal team telling him what the heck to do.
Right, but again, it was, and Ellen, it was 50% of the property, correct, and 20% of his yearly income.
50% of anything that Mr. Strahan chose to put in joint names with
I
no
see.
obligation that he put anything.
I see.
What also is important is that Michael Strahan was again advised about this premarital agreement in 2001 by one of the attorneys who was still on his team when this case was tried. So by his team, I mean his legal team, obviously.
Right.
But when the case was, when the agreement was signed in 1999, he looked at it again in 2001 and essentially reaffirmed it through his counsel and Jean. So I can't imagine how there could be any expectation that it wasn't enforceable.
Well, thank you for the information you've shared with us tonight regarding the Strahan case. Maybe a lesson to be learned is the Michael Jordan divorce, where we didn't hear too many of the so-called lurid details, and Juanita Jordan walked away with over $150 million, close to $200 million, in what Fortune 500 or Forbes magazine calls the most expensive celebrity divorce. It probably pays custody matters, support matters, alimony, etc., equitable distribution, divorce in general, just to keep your mouth shut. Bottom line. And it's time.
That doesn't sell newspapers there.
No, it does. No, it doesn't. But it might make litigation just a little less harrowing for your client, Dave. No?
Probably.
It is time for Hot Topics in Family Law. Let's take a look at what's going on in New Jersey, Pennsylvania, around the country. We tackled grandparents' rights the last time Bonnie, Don, and Dave were here on the set. I don't think we made it real clear, but it's interesting that both a Pennsylvania case and a New Jersey case, I think, are illustrative of some of the things that we're talking about and where grandparents' rights are today. The Hiller versus Fauci case, which was a case that went to the Pennsylvania Supreme Court. The United States Supreme Court denied certiorari. They're not going to listen to it. The Rente case in New Jersey Superior Court, the Appellate Division, dealt with grandparents' rights and visitation. Here's what it appears to be coming down to. Some states across this country believe that grandparents' rights, visitation, if you will, custody, comes down to the best interest of the child, where some states make the grandparents prove that there will be irreparable harm to the child unless the grandparents are allowed to visit them. Those are the two tracks we're kind of going down in this country right now. And the New Jersey case, the Rente case, essentially grandparents visiting the kids, they didn't meet the threshold of demonstrating irreparable harm. Grandparents don't get visitation rights.
Well, our New Jersey statute has, I think it has 13 factors that that the courts have to look at as to whether or not grandparents should be given any separate right. And in this case, there was a factual distinction. The custodial parent was giving time to the grandparents. So the grandparents were able to see the children. The grandparents, however, had sued for an independent and separate right to have separate time, not just what the custodial parent permitted them to have. And so it was under those circumstances where the grandparents only periodically babysat, whereas the statute says has a continuing, living arrangement with them, or they babysit with them for weeks, years on end. they didn't meet the factual scenario that fit in with our statute. So factually, that's where they fell apart there. But yes, the burden shifts to the grandparents to meet the factors to show that the children are going to be harmed because
Right.
they have a separate, independent, long-standing relationship with the child.
You don't have that threshold in Pennsylvania, though, do you?
We don't have harm for the child. Now,
Right.
the Hiller case that you were talking about was a factual scenario where the grandparents, their daughter died of cancer, and they got independent visitation rights under a section of Pennsylvania statute. So that was the statute that went up. Of course, what they're dealing with in these cases, and I think why it went to the Supreme Court, is the issue of the fundamental rights of the parents to parent their kids, and whether or not there can be any quote-unquote interference with that fundamental right. And the first time it went up to the Supreme Court, the Troxel case from out west, I think that statute provided grandparent rights even with intact families.
All right. Irreconcilable differences. It's hard to believe in the state of New Jersey, this has never been a driving force. There's never been a fast track, if you will, for divorce in the state of New Jersey, who we always laud as being so far ahead of the times in various sectors of and practices of the law. But New Jersey's never really had that. Now you do.
Now we do. As of, I think, January 21st or thereabouts, our legislature passed an act that all we have to allege as a cause of action for divorce is that the marriage in the last 6 months has irretrievably broken down and that there's no prospect of reconciliation.
And Ellen, how long do you have to wait? Is it just the 6 months and that's it, and then you're out of there?
Well, you're not out of there, but you have a cause of action when you can say the marriage has been broken down for 6 months or longer.
You don't have to wait, right, Ellen?
No,
I mean, you don't
no.
have to wait.
No, there has to be 6 months to file the complaint, and then off you go. It makes the business of divorce much more civilized and no more need, unless there are very particular reasons unique to the case, to recite acts of extreme cruelty. It encourages, in my view, privacy.
Next item up on the list of hot topics, civil unions. New Jersey, of course, late last year said that civil unions would be recognized in the state. New Hampshire has now stepped down that track as well, Don.
Yeah, in Pennsylvania is the other way. There's a statute in Pennsylvania that says that marriage is between a man and a woman, and that follows the Federal Defense of Marriage Act,
Right.
and doesn't even have to recognize marriages or civil unions from other states.
Well, not unlike the Commonwealth of Virginia, where I hail from. Dave, I'm going to let you handle this one real briefly. The Stroud versus Stroud case, where in Virginia, not only is there no such thing as civil unions, but there's also a constitutional amendment in the state, which essentially bars anything that looks, walks, talks, or acts like a marriage between people of the same sex. And yet, curiously, in a case that went to the appellate court in the state of Virginia, they said that an ex-wife's relationship with her girlfriend constituted cohabitation in a situation analogous to marriage for purposes of terminating the ex-husband's spousal support obligation. So Judge LaDove, so to speak, I'll put quotes around the name.
Thank you.
The modifier judge.